And good afternoon. Thank you for coming. The topic is court opinions, recent court opinions in cyber law. We're going to go a little bit further than that and discuss some related matters. And I'm very proud to have an outstanding panel. Sitting 2 seats to my right is the Honorable Bernice Donald, who sits on the Sixth Circuit Court of Appeals. A judge who, and I confirmed this over lunch, I thought I knew the truth. I was right. She has been both or in addition to being a circuit court judge, she's been a district court judge, a bankruptcy judge, and a county judge. So she knows what she's doing. To my immediate right is Dr. Barbara Simons, who I've known for some 20, 25 years. Dr. Simons was a research scientist at IBM in computer science. And she has been the president of the Association for Computing Machinery, which is roughly the equivalent for computer professionals as to what the ABA is for lawyers. More recently, she has been, you sit on the election assistance?
On the Board of Advisors.
For the Election Assistance Commission, and recently has been named chair of the Cybersecurity Subcommittee?
Election security, yeah.
Okay, thank you. To my far right, we'll get to that. To my far right is Dennis Riordan, who is one of the preeminent attorneys in the computer science field. He has prosecuted, or pardon me, Dennis. He has argued the case of United States against Nozzle, which is a seminal case interpreting the Computer Fraud and Abuse Act. And finally, but not least, is Alan Butler with the Electronic Privacy Information Center, who has his hands in all sorts of cyber law issues. More recently, he is an author, co-author on a brief concerning election security filed in Northern District, filed in the Middle District of Georgia or Northern?
Might just be District of Georgia. I can't.
No, it's Northern.
Yeah.
I'm pretty sure it's Northern.
Okay.
And if I'm wrong, somebody will correct me. All right, the topics we're going to hit, and not necessarily in this order, but the first one will be electronic voting. And I sub-captioned it, broken ballots. And the reason I did that is because Barbara is the co-author of a book with that title on electronic voting and electronic security. After that, Sons of Carpenter. You may recall there was a very important case that came down from the U.S. Supreme Court last year called the United States against Carpenter concerning cell phones and privacy. And it has spawned a number of cases from the appellate and district courts, and we're going to examine a few of them. Then the Computer Fraud and Abuse Act, which continues to cause problems with the definition of unauthorized access and how it is to be interpreted when somebody has access to a computer but decides to use it for the wrong purpose. Then we go to predictive algorithms, which basically is artificial intelligence, big data, and to what extent that information can be used to make decisions about somebody's career, life, or sentencing, and when it's done, to what extent the person who is subject to those decisions can get access to the algorithm or to the data that the algorithm is using to function. We'll also take a look at the general data privacy regulation in the European Union and its effect on internet activity across the globe, and finally, malware in the courthouse. With that, I'm going to go to electronic voting, and the subcaption that I chose is Republic, if you can keep it. You may or may not be aware that Benjamin Franklin, when the United States Constitution was being written, was asked by somebody who was outside of the building where the founding fathers were located, and was asked, what kind of a government have you given to us? And his answer was, a republic, if you can keep it. And we have a question, given the security or lack thereof of our voting systems, whether indeed we will be able to keep that republic. There's a case presently pending, Northern District of Georgia. I thought so. Actually, I didn't, otherwise I wouldn't have asked the question. Curling against Raffensperger, and the court itself framed the question that was presented to it as follows. This case challenges the constitutionality of the state of Georgia's use of direct recording electronic voting machines and associated software systems in today's era's heightened cybersecurity threats. I am not going to read all of these points that are on the PowerPoint presentation, but I'm going to ask Barbara if she could highlight for us some of the issues that the courts have had with regard to cybersecurity and electronic voting, and why we are having such a controversy today.
First I should say something about what DREs are. So these are typically these touchscreen voting machines. You've seen pictures. Thank you, Andy. You've seen pictures of people going to vote and then complaining that they pushed this button and a different candidate showed up, and they're saying, oh, the machine's being rigged and so on. So these, of course, are computers, and the ones used in Georgia are all paperless, so there's no way to check your vote. There's no way to do a recount, no way to do an audit. But more important, I mean, just to give you an understanding of why these machines are so bad, what you see on the screen may not be what's actually recorded as your vote. What's recorded as your vote is inside the memory of the computer, which is a different component than the screen. It's the same thing with internet voting. What you see on your screen when you do something over the internet, anything, send an email, anything, may not be what goes out over the internet, because there's stuff inside your computer that takes that and can change it. So what you see is just one of the components of a computer. And it's the same thing with these DREs. What you see on the screen may not be what's recorded in memory. Because of that, these machines are not reliable and they are fundamentally insecure. The ones used in Georgia were first used in 2002 in an election where Max Cleland, you may recall, lost his election even though he was ahead in the polls. And of course, there was no way to check the results to see if they were correct or not. We know that software was being changed at the last minute with no oversight. And of course, the software is long gone, so there's no way to check it. So these machines have been used in Georgia up to the present day. They've caused a lot of controversy. What I was muttering to Andy before is I'm board chair of Verified Voting, which has been working in this area since the early 2000s. And if you go to our website, verifiedvoting.org, you'll see on the front page a link, just scroll down a little bit, you'll see a link to a video made by Alex Halderman, who's on our board of advisors, showing how he can remotely hack into the Diebold, these machines are made by Diebold in Georgia, a Diebold DRE, and change the results remotely. So we already knew they were insecure, that there were ways, if you could get your hands on the machine, that you could change the votes without anyone knowing. But now we also know that you don't even have to be physically present. You can be in another country, another state, and you can change the results. And these are the machines that Georgia has used since 2002. And they used in 2016 and 2018. And there's been a lot of pushback from the computer science community about these machines in general. As of 2018, there were still 5 states that were totally paperless. And Georgia, of course, was one of them. There is a law that's been passed that is supposed to replace these machines by 2020 with paper ballot-based systems. I don't believe those machines, well, I'm not quite sure what the status is of the selection of those machines. But this lawsuit that Andy's talking about they originally went to court to try to get paper ballots used for the runoff election for the House. I think it was District 6, was it? I believe that was right, in Georgia. Because, again, it was a relatively small area, just one House district, choose between 2 candidates. it would have been very easy to hand-mark paper ballots and manually count them. But that effort failed, and so that runoff vote was also held on these fundamentally insecure machines. I should also mention that in the 2018 election for governor, one of the candidates for governor was also the head of the office that oversaw elections in Georgia, which to me seems like just a blatant conflict of interest. Let me see. So what do you want me to talk about?
Well, I'm going to switch over to Alan. There's a court case going on in Georgia. You filed a brief in that case. What's the argument that's going on?
Sure. So, as you mentioned, there's a court case in the Northern District of Georgia. The case is called Curling v. Raffensperger. There are two different groups of plaintiffs, some individuals and others representing both individual voters and a coalition dedicated to addressing these voting insecurity issues that are suing the Secretary of State and also local election board officials in their official capacity. And that case has been ongoing since 2017. They initially made an effort to get an injunction to block use of these DRE machines in the 2018 election. And that failed in part because the court felt there wasn't sufficient time for the state to deal with the change, and so the court didn't consider it at that time. Now there's a new injunction action prior to the 2020 election, and the court is considering that. They just had a hearing on the 26th of July on that injunction motion. The core legal issues in the case are civil rights claims. They're a combination of civil rights claims under the fundamental right to vote, alleging an undue burden on that right, as well as due process and equal protection claims, and interestingly, a claim that the systems being used in Georgia violates the right to the secret ballot, which is related. I can mention briefly. So essentially, the plaintiffs in the Curling case have taken all the issues that Barbara highlighted regarding the vulnerability and inability to audit the use of these paperless systems, and are arguing to the court, have argued so far successfully to the court, that those vulnerabilities actually give rise to an undue burden on their right to vote, because they're being forced to choose between voting through an absentee ballot system where they have to, where there are many additional restrictions on their right to vote, such as different registration requirements, different timing requirements, the actual cost of mailing, et cetera, or choosing to vote on these DRE machines that are fundamentally insecure and cannot be ensured that their votes will be properly counted. So what's happened in that case so far in the most recent iteration is that the state government has filed a very broad motion to dismiss all the claims on many different grounds, procedural and substantive, and they lost on all but one narrow set of issues. So the court in May of this year denied the government's motion to dismiss. So the case is moving forward. The plaintiffs, as I said, are seeking new preliminary injunctive relief. Ultimately, what the plaintiffs are seeking is a declaration by the court, or a declaratory finding that the use of DREs is unconstitutional as an undue burden on the right to vote and due process equal protection violation. They also want an injunction that prohibits the state from using the DRE machines, obviously, and requiring post-election audits, as well as access by observers to the full election process. So it really is kind of a comprehensive case addressing the fundamental vulnerabilities involved in the use of these DRE machines. Now, as Andrew mentioned, my organization, the Electronic Privacy Information Center, that has worked with verified voting and Barbara in the past on these issues, we filed an amicus brief in the case, which is a little rare because this is a district court case. Most of the time you're filing amicus briefs in appellate court or maybe the Supreme Court. It's rare to do it in district court, but this case is very significant, as you can imagine, based on the background you've heard so far. And our brief really highlighted, one, in part, of the issues that Barbara has been talking about that have to do with sort of the nature of the fundamental vulnerabilities of the DRE systems, and also highlighted the importance and history of the secret ballot, the right to ballot secrecy in America. One of that related issue in this case has to do not with the DRE machines themselves necessarily, but how Georgia's system of registering and tracking votes works. So there's an allegation that at the same time that these systems not creating a paper auditable trail, it is also generating data about votes, including a unique, basically a unique code for each digital ballot, as well as a timestamp that could be used by the state to actually connect specific votes with specific voters, given the amount of information the state has about, when people show up at the polling place and when they cast their vote. So there's simultaneously a problem with the insecurity of the system and the lack of auditable paper trail of the votes, and also a problem with the amount of data that's collected about the vote when it's cast that could be linked to a specific voter and potentially violate the right to a secret ballot. Also, just note quickly that this case would be the first, if the court finds for the plaintiffs, to affirmatively find a right to the secret ballot in the Constitution. So it's really interesting in that regard.
Yes.
And just to add to what you said, it would also be the first time that technologists have been allowed by the courts to inspect these systems, because previous efforts to do this, we have been rebuffed time after time by courts saying, well, show us that there's that you have some reason to suspect that there's a problem. And we say, well, we can't show you that there's reason to suspect that there's a problem without looking. It's what attorneys do, which you
Confidential.
No, where you get, you.
Protective order.
No.
Well, you want to look and what? Well, that's probably not either. But you know what I mean. You can get access to information.
I said, I think they're accusing, when you're talking about discovery, they're saying that.
Discovery.
Yeah, right.
Oh.
Sorry, I'm not. It's like you guys can do discovery, but we can't. I mean, we have to be able to show that there's a problem before we can go and do the discovery, which we need to do, which is look at these machines. And then one final quick comment. The reason this case is still relevant, having just said that they passed a law to get paper ballots, is that they don't have those paper ballots yet, and they won't be getting them until 2020. Hopefully they will for the 2020 election, but meanwhile, there are other elections that are ongoing that this case addresses.
Yeah, I think the problem that you were identifying is that the courts will protect the assertion that the software and even the hardware is proprietary, is confidential, and you can't look at it unless you can show there's a problem.
Right.
And often you can't show there's a problem unless you look at it.
Exactly. It's catch-22.
But, but in that situation, I understand that catch-22, but, there are issues where you have very confidential things and allegations around trade secrets, and courts find a way to bring in a designated expert. They cloak them with confidentiality, and if the judge doesn't have the necessary background to view that, they can do this in-camera thing through their appointed agents. So I think that the fact, whatever the assertion is, we have got to get around that, because technology and AI is becoming more and more sophisticated, and because it's proprietary, I think should not, and I'm not arguing one way or the other in this case, but should not shut down the ability to at least discover. And maybe the adverse party doesn't get to discover, but a neutral one appointed by the court or the court itself ought to be able to discover and then keep confidential once the judge determines whether or not it is relevant to be disclosed.
I don't want to dominate this, just one quick comment. One of the problems with software is you don't want to just be able to read it. You want to be able to experiment with it to see if you can find a hole.
Yeah.
And that makes it harder.
Of course.
We can't even get to look at it often, but that's what you can't just read it and find out that there's a problem necessarily.
Yeah. Either Alan or Barbara, this court case is brought in Georgia. Are there similar problems that have occurred or have been identified elsewhere in the country?
Do you want to take that or should I?
You can go ahead.
Well, I mean, the situation in Georgia is blatant because there's been a lot that's happened, such as a cybersecurity guy happened to discover large numbers of files that were supposed to be secret about voters and about elections information in Georgia that should be secret. He just found them. They were not protected. And he, to his shock, downloaded file after file after file of material that should be secret. And even after he reported, nothing was done for 6 months. So there's all kinds of, I mean, the Georgia case is really extraordinary, which I think is one of the reasons why there's maybe be some success with this lawsuit. But things happen in other states too, where insecure voting technology is used, and it's very hard to know whether or not the reported results are correct. We just don't know. So what we have in this country, instead of having evidence-based elections, in many ways we have faith-based elections. And we really need to move our elections to a point where we can prove that the candidate who was declared the winner truly won. We know how to do that, but we haven't implemented it in most of the country.
Okay. I want to say one more thing on this, and then we're going to move on to another topic. When Barbara talks about the difficulty in identifying a problem with election software, the problem that they're having is this. You have code, often it's object code, a series of zeros and ones or hexadecimal symbols, which don't mean anything to a human being who's looking at it, even if you are an expert, because you have millions of lines of code. And I remember the movie Jurassic Park, where one of the characters puts a malware patch into the software running in the park. And they have to go through line after line of code one at a time. And the owner of the park turns to his computer scientist and says, how many lines of code do we have? And he says, 2 million. That's the kind of a problem that you have. Unless you know what you're looking for and can figure out where the problem must be located so you can zoom in, you don't have the ability to find the problem. So that's the difficulty in these protective orders and surrounding confidentiality, proprietary aspects of computer software. Okay, we're going to move on to the next topic, and that's going to be cellular surveillance, sons of Carpenter, as I refer to them. Last year, the United States Supreme Court came down with a decision which expanded the scope of privacy and limited the third-party doctrine. And what that means is that in the past, if you gave your information to a third party, say some business, a financial institution, or a cell phone company, and the government wanted that information, they did not need a warrant. They could ask for it, it could be turned over, or a subpoena could be issued by a grand jury or maybe an administrative subpoena, and the government could get that information that way. The defendant, Carpenter, was tracked using his cell phone for a lengthy period of time, and the court said that that is a search and a subpoena is not sufficient. You need to get a warrant supported by probable cause. The underlying principle there is that the use of cell phones and computer technology is so pervasive today that you don't have any sense of privacy unless you can tell third parties that hold your information, that's mine, and the government's going to have to get a pretty good reason to get it from you, and that means a warrant. So that being said, I'm going to ask Alan if he could talk to us about some of the cases that have come down, and I have them in a particular order, but feel free to tell me if you want to move them into any other order.
We can go in the order that's in the slides, it's fine. So, as Andrew mentioned, the Carpenter case was really a significant, really significant Supreme Court opinion under the Fourth Amendment and marks kind of a bit of a sea change in how privacy rights are going to be determined by federal courts under the Constitution. But Carpenter is also one of a line of cases in the last 5 years that has substantially changed the way that courts approach these types of digital privacy issues. And so the cases we'll be talking about today are more recent opinions post-Carpenter that deal with some related issues, not only going back to Carpenter, but also going back to a number of other recent opinions. So just to quickly touch on other things, Andrew mentioned Carpenter was focused on cell phone location data, what's called cell site location information, basically the fact that every one of these devices in our pockets is constantly creating records of where we are all the time that our cell phone company has access to. And the question is, can law enforcement get access to that data without a warrant? The Supreme Court said no in Carpenter. In United States versus Coria, deals with a slightly different issue that goes back to actually a case that led in part to Carpenter, which was the Jones case. Another related case was called Hardenis. Jones was about not cell phone tracking, but the actual use of a GPS tracking device on a vehicle. And the issue in that case is the Supreme Court found it was not that they were tracking the person over 28 days, but that they had physically attached a GPS device to his car. So Coria asks the tricky question of what happens when you are using an electronic device to send out signals when law enforcement seizes someone's electronic device, in this case a garage door opener, a key fob, and uses that device to gather information that they otherwise couldn't have. So this person was pulled over at a routine traffic stop, consented to the search of his vehicle. Officers found in the vehicle several different garage door openers, keys, key fobs, suspected him of other unlawful activity, used those devices to drive down the street and find his garage door to figure out what building he lived in, used the key fob to go into the common space of the building, used the mailbox key to test the mailboxes to figure out which apartment he lived in. And so this kind of raises a number of questions under this trespass doctrine. And ultimately the court found that these combination of actions by the police officers, some of them were searches under the trespass doctrine and others were not, but none of them were unreasonable, even though they didn't have a warrant. This really goes back to a fundamental issue about I think the difference between the protections that are attached to a home versus the protections that attach to apartments or other types of living spaces. There's a major decision in the Ninth Circuit that had to do with sort of police investigating something related to an individual's car when they lived in essentially a mobile home, as opposed to if you lived in a brick and mortar home and you had a physical enclosure. So there's kind of a disparate impact issue that's underlying this case, I think. But I think ultimately this case isn't super digital except for the key fob and the garage door opener. That part is pretty interesting because the actual use of a digital device to send out emanate digital signals into the world, I think is different than what we've seen in a lot of other cases. But the court essentially found it was de minimis. So it would be very interesting to see if courts other than the Seventh Circuit end up with similar cases in the future and if they go in different directions. But that's Coria.
All right. Move over to United States against Contreras.
Contreras is, I think, out of the cases we're going to talk about here, the most kind of directly a direct application of Carpenter in a different context. So Carpenter was about cell phone location data. Contreras is about the subscriber data that attaches to an individual's internet service account. So the officers in Contreras were investigating an individual who accessed or distributed child pornography, and what they knew is that signal came from a particular internet service provider and a particular IP address, and they were able to go to the internet service provider without a warrant and obtain the physical address of that account. And there was an allegation by the defendant, who was ultimately charged and convicted, that that warrantless search was unreasonable. The court found that it was not, because that type of subscriber address information the court felt was similar to what would traditionally be available through a subpoena or from a third-party service provider. I think that outcome is sensible even under Carpenter, because what Carpenter ultimately was dealing with was a fundamental difference between the type of information that's available on and because of cell phones, the quantity, the quality, and kind of the unique character of data generated by cell phones and location data in particular, as opposed to what's been traditionally available, like data about when calls were placed or received, or in this case, account information. But this case is an interesting data point in the post-Carpenter world, especially because the Carpenter decision itself was divisive in the sense that it was a 5-4 opinion, and all 4 Supreme Court justices who dissented in the Carpenter case wrote separate opinions, which is very rare. And Justice Alito in particular was sort of arguing that the Carpenter decision would lead to a bunch of very strange or disparate decisions below. This case, I think, is a data point that shows that actually, much of the old traditional applications of the third-party doctrine probably will stay the same, and Carpenter likely will leave a legacy that's more applicable in a digital context. So that's Contreras.
To me, it seems like this is probably one of the more difficult fault lines we're going to see with Carpenter and the third-party doctrine. Any other cases of which you're aware out there, or any other issues related to this that are on the horizon?
Related IP address or similar post-Carpenter. I think that there will be a lot of cases about digital devices that aren't cell phones. So about computer searches and about I think the big next disputed area related to digital searches is not actually going to be about the third-party doctrine, but is going to be about the Fifth Amendment and the decryption of devices, which includes cell phones. So I think the Carpenter legacy will continue in disputes over when officers can and cannot force an individual to unlock a device, whether it's a cell phone or a computer.
So, Ellen, what about? Do you see that there'll be issues around those devices that everybody is getting, the gifts or other things, where you put them in your house and you tell it to turn on the TV and turn on the this, and then it listens to things when it's perhaps not supposed to be listening?
I don't let that stuff in my house.
I don't either, but some people, a lot of it's, I got one as a gift that's still in my house. Because I know so little about this till it scares me. So what about that kind of stuff? I understand that if criminals have that and they're talking, that this thing might very well be a witness against them.
I think you're absolutely right. That is another major application of this Carpenter concept, because it goes back all the way to the fundamental tenets of privacy law in the United States, which is that listening devices placed in individuals' homes are a per se violation of privacy, a per se invasion of privacy. But it gets complicated when the individual places the device in their own home, right? But obviously people that use, some people may or may not choose to use these devices, but no one is putting these devices in their home with the intention of people listening to their conversations, right? At worst, they're putting them in their home with the intention of giving commands to a digital assistant to carry out specific things. Search for this, tell me what the weather is going to be like tomorrow, tell me what's on the news. In the case of one example, an Amazon device, you can actually log in and see, what commands you've given the device. On your account, you can see, okay, here I searched for this, and it'll actually show you what you said. So there's a log of what you said, and you can go in and delete them. But there's been already issues where law enforcement wants to get access, not even to those commands, but just to the passive vocal data that's being collected incident to the device listening for a command, right? So you say, Alexa, tell me what the weather's going to be like tomorrow. That's a command. It provides a response. At least there, you know that you've requested something and it's delivered it. But up until you say the word Alexa, there has to be a microphone turned on waiting for you to say Alexa. So anything that you're saying before you give a command is potentially temporarily caught on the physical device. And law enforcement has tried, in some cases, to get access to that data, which there's no relationship to a third party with respect to that data. So there's a lot of really tricky issues with those devices. Also, I may decide that I want one in my home, but if you come over as a guest in my home, you never decided that you wanted to use it, but you're talking in its proximity. Some hotel chains have installed them in hotel rooms. And so it's not even so much of a, my concern is that some courts or some litigants will sort of try to put the onus on the individual and say, oh, well, you purchased this thing or you used this thing. But this technology is so pervasive that you can't choose not to be exposed to it. I mean, devices in stores, phones that have built-in voice recognition technology, they might be your phone, it might be a colleague's phone. Like I don't know that people can anymore avoid being exposed to always-on type devices that have active microphones.
All right, let's move on to the Heron case out of the Second Circuit. And the question I have of Alan is the good faith exception going to swallow up a good part of Carpenter?
I think that with Carpenter, so to give a little bit of background, the good faith exception provides that when an officer, even if an officer conducted a search or otherwise took some action that violated the Fourth Amendment, but did so based on good faith reliance on a court order or some other official understanding of the law at the time that the search occurred, that the court will not find that was, that will not suppress the evidence, would not hold the officer liable. And so frequently when the Supreme Court issues a new decision that kind of breaks new ground, there's a period of 5 or even 10 years where old cases come up and they ultimately get dismissed on this basis. And so it takes the law a long time to move in the Fourth Amendment context because lower courts can't ever actually reach the ultimate question if it's novel. This case, I think, is more of a typical application of the good faith exception because it is fully within the boundary. It's very identical to Carpenter, it just happened prior to the decision coming out. So I think this is a standard application. I'm more concerned with situations where there's kind of a novel issue that comes up and a lower court says, well, we're not going to reach it because even if we did reach it, good faith exception would apply. And that really delays the proper development of the law. So I think that this case is kind of a typical example of pre-Carpenter cases aren't going to be subject to suppression, but otherwise doesn't have significant implications, I don't think.
And our last one under this category, United States against Eglin. Alan and I had a little discussion as to whether this should even be included as a case under Sons of Carpenter. I think it is, and since I got to choose the cases. Alan?
I think so I think it is in the sense that you have the Carpenter decision, again, about cell phone location data. Before that, the Supreme Court a few years earlier in 2013 had the Riley decision about searches of cell phones data itself. That creates kind of a cell phone law, the law of the cell phone, or the law of digital devices, I would call it. And this case is certainly within that rubric. But more relevant, I think, to this case is the Supreme Court's decision in Packingham, which I'll describe in a second. So what this case involved was sentencing of an individual who was convicted of failing to register as a sex offender. And the sentence that he was given prohibited him, gave a broad ban on accessing internet services and also a broad ban on the possession of what would otherwise be legal adult pornography. The court struck that down and found that the lower court abused its discretion in imposing such a broad sentence, especially given the nature of the crime. What happened in Packingham is the Supreme Court ruled that a North Carolina law that had imposed a restriction on any registered sex offender to access any social media site was unconstitutional under the First Amendment because that social media sites and the internet more broadly, because Epic filed an amicus in that case arguing that the definition that was given in the law was so broad it would cover the New York Times website. That inhibiting access to the digital public square was a fundamental First Amendment violation. So this case is not squarely, the Eglin case isn't squarely a Fourth Amendment or First Amendment case because it's actually about sentencing discretion, but I think it implicates both issues because it has to do with the use of the cell phone to access information about the world and also has to do with access to the public square, the ability to share and receive information legally when disconnected from sentencing.
Okay. All right, let's move on to the next topic. The Computer Fraud and Abuse Act. This is yours, Dennis. You've been sitting there quietly, but now it's showtime for you. And I want you to know, as I mentioned at the introduction, Dennis argued the Nosal 1 and Nosal 2 cases, which are the preeminent cases in the area of defining the unauthorized access of a computer for purposes of the Computer Fraud and Abuse Act. You want to give us a lead-in to those cases and then these?
Yeah, and let me give you a lead-in to the Computer Fraud and Abuse Act in a couple of words. It was originally passed around the time of War Games, which was a movie with Matthew Broderick about a computer high school nerd who tapped into the Pentagon computers at a time when there might have been a relatively small number of mainframe computers in the United States. I believe the latest amendment to it, meaningful one, preceded the existence of smartphones. So that's simply to say that the Computer Fraud and Abuse Act and its language was written at a time when no one could have possibly imagined what was coming. That is to say that virtually, or perhaps almost all Americans, would be carrying around in their pocket a computer with a greater computing power, I suppose, than the Pentagon had in 82 or so forth. And the definition of a protected computer, which invokes federal jurisdiction, applies to every cell phone, every laptop, et cetera, et cetera. So you have a situation in which arguably every act of misconduct, which might involve any kind of a device that can connect to the internet, can invoke federal jurisdiction. What has happened is that a lot of litigation, like the Nosal case, arises in the employment context, and it arises, as in that case, where someone leaves a company, and then there's a dispute about their gaining access to information from the company that they left. Now, one of the things here is that a lot of these are really about the violations of, in the company's view, of non-compete agreements. But we're in California, and as you may know, non-compete agreements in California are illegal. And I believe it's the case that a lot of the major tech companies in the world are centered in California, which means when a company is unhappy about the leaving of an employee who they feel may have access to trade secrets and so forth, they can't rely on non-compete agreements. Generally, what the dispute is about trade secret claims, which can be tricky. And I submit to you, and I hope to get to an example, that what the Computer Fraud and Abuse Act does provides another Louisville slugger, that if you're going after somebody that you think has information that you wish they didn't have and has gained access to it, you not only have the federal trade secrets law, state ones, but you can have state and federal computer abuse acts. Very quickly, out of one case, Nosal, two significant opinions came from the Ninth Circuit. One of them was an employee, a major player in Ferry, one of the leading executive recruiting firms in the world, leaves, takes a couple of young recruiters with him to start his own company, but leaves behind a secretary who is going to join this group thereafter. She's still at Ferry. In one set of charged offenses against all four of these people, it was alleged that the people who had left got in touch with the employee who was still there, and what this is all about is research lists. There's a list of executives and where they work and what their background is, which is what you use when you do executive recruiting work. And that she gets into it, the secretary does, and sends this information on to the outsiders who are working on putting together their new firm. Those were argued, the government prosecuted and charged, and in an interlocutory appeal, a set of charges was dismissed in which there was no question that the secretary as far as the company was concerned, had access to all these lists. She was authorized to get them. But the argument was made that authorization to get this list ends immediately on the intent to use it for anything other than a purpose approved by the company. And the Ninth Circuit came out, initially the charges were upheld by a 3-judge panel. An en banc panel in an interlocutory appeal ruled that no, if you have access, if you're given access to a computer and you do something that the company doesn't like with that information, you may be fired. You may have committed a trade secret violation, but you have not acted in excess of your authorization. And the litany that they go through there is, look, everybody knows that when March Madness comes around, people get on their computers and are spending a lot of time looking up who did what and so forth and so on. None of that is authorized by company policy. And if we make the company's policy and allow the definition of a federal offense to be defined by a company's policy, we've expanded criminal jurisdiction immensely. The government argued, oh, but we won't charge those kinds of cases. They said, no, we're not going to leave this up to the discretion of prosecutors. That does not constitute exceeding access, even if it's for an improper purpose. If the purpose is illegal under another statute, prosecute under the trade secret statute, which they did in that case. Then post-trial, they get a second case, which is now the secretary comes over, visits the people who are out starting this new office, and while outside the firm, taps into the computer, which she's been given access to, but then allows someone to sit at the desk, get into the computer, and download them themselves. So here we have a situation where an authorized person is entering the computer, but then somebody who is not authorized, they've left the company, is downloading the information. The Ninth Circuit says that that is acting without authorization. That person isn't someone who exceeds authorization, arguably like the employee. The non-employee has no authorization. She's acting without authorization, which is a separate provision of the CFAA from exceeds access. Exceeds access without access, okay? What was brought up there is that the authorization, if you're not in a company, often comes from the service provider. So that is to say that Facebook, for instance, says that no one who gets into their computer can get into the computer who isn't the Facebook account holder. Well, what happens when parents decide that they're going to use their kid's password to check and see what they're doing on the computer? And you can multiply examples where under the without authorization provision, a lot of innocent people would be guilty of federal offenses. What the Ninth Circuit said is, we'll get there someday, but all we're saying is in this context, it's without authorization. So there's a huge amount of issues out there under the without authorization provision. Let me say on the, very quickly on the exceeds access, there is now a circuit split with two circuits, the Ninth and the Fourth, ascribing to Judge Kaczynski's opinion in NOZA 1. 3 circuits going the other way. It is an ideal case. The government could have taken it up in NOZA 1. It would seem like cert would be granted. They decided not to, I think because they didn't want that conflict necessarily resolved. So it's out there, and it remains out there. Since then, we have 2 cases that we're talking about today. The state of Oregon versus Nascimento, which was an employee who had access, was supposed to buy and dispense lottery tickets. Well, it turns out what she was doing was dispensing a lot of lottery tickets to herself. There was a theft charge there that was separate, but they argued that that was an unauthorized, she had exceeded access. And under state law, tracking the CFAA, the Oregon Supreme Court said, no, because she was entitled to get into the computer to dispense the tickets. She was not outside her authorized access, even though she was doing it for an illegal purpose, and they prosecute her under theft charges. Then we have a case from the Court of Appeals in Texas, in a civil case in which the allegation was that certain employees who had access to computers and information had decided to leave the company. And they didn't tell the company that they were going to leave. They continued to access these computers and so forth. The Texas court said that was a violation of policy, company policy. So unlike NOZA 1, it said that that does constitute unauthorized access, which is simply to say that the issues of without access and the issues of exceeding access are still split. Conflicting opinions continue to come down from state and federal courts, and no doubt will continue until at some point the Supreme Court steps in and addresses those issues. I will say in the Cimento case, what was, they decided on that on without access. So they effectively said it isn't, it doesn't exceed access, it isn't without access, because the local grocery store gave their employee full access to the computer for the purpose of dispensing lottery tickets. Let me leave it there.
Yeah, I want to say something about the Computer Fraud and Abuse Act. Not quite on point for exceeding authorized access, but on the point of access at all. Are you allowed to have access? I handled a case defending a small company that had as its business model, it would scrape or visit websites of major companies that were marketing merchandise. And in this case, the plaintiff was QVC, which is one of the home shopping networks. And they had on their screen for their, if a person wanted to take a look at their website, a banner that said, we do not allow automated downloading or examination of our website. Okay, it seems pretty clear you don't have authority to use a computer to access their website. On the other hand, there's a little file that's in most web pages. We won't see it because we're human beings, but other computers can see it. It's called a robot.txt file. And in the robot.txt file, it said, computers come in and examine our website. So what my client did was to have a computer that, would scan the internet periodically to find these items that were being sold and their prices and their quality, et cetera, and then would market it to or provide that information to third parties. And they do it using automated means. So the question is, which of these two warnings or notices do you follow? The printed one for a human being that says you can't use an automated device, or the one for an automated device which says, yeah, come on in, take a look at what we have. Unfortunately, that decision on that topic was not decided by the district court. It was resolved in other matters. But the Computer Fraud and Abuse Act, as you said, was not drafted for today's technology. Yes. So,
as the non-lawyer on this panel, which you obviously realized when I first started talking, I have a question about the CFAA. So, and this may be really a silly question, but I'm going to ask it anyway. So one of the concerns that we have had, those of us who are fighting these insecure voting technologies, is the fact that the software is proprietary. And of course, these are national, state, local elections we're talking about that are being controlled by secret software, and that there are lots of methods that are used to prevent computer security experts from examining and testing the software to see whether or not it's reliable, whether or not it has malware, whether or not the elections are being rigged. So one of the things that's used, of course, is the DMCA, Digital Millennium Copyright Act. If there's any effort being made to protect it, then then by going in and looking at it or breaking the protection mechanism, even if it's really crappy protection mechanism, you can be found guilty of of violating the DMCA, or that's at least the fear that we have. Could you also be found guilty of violating the CFAA by going in and not trying to rig an election, but just trying to see if the software is reliable or not, if the software has vulnerabilities, if the software is being used to rig elections?
Well, I think that gets to the heart of one of the divides here. The argument against an expansive view of the CFAA is that it was designed to be an anti-hacker statute. People outside coming in, getting passwords, so forth and so on. The debate in these opinions is, no, this is supposed to be an anti-hacker statute as opposed to just a violation of company policy statute. It sounds like the question that you're raising would fit in the more limited view, which is if somebody went in and was able to get to this software to test it or whatever else, but did it without authorization from the company that owns the software. Is that the question? What you'd have to do in a criminal case is say that there wasn't a fraudulent intent, which is an element of the criminal case. However, as Judge Kaczynski pointed out, the civil statute doesn't have the fraud requirement. So therefore, there doesn't have to be a malicious or fraudulent intent if you get by barriers in order to get to this software. If that's a germane answer to your question.
Well, I do think it's germane, and thank you. I mean, one of the problems that we've had, a lot of us, with the DMCA is, again, intent is not a factor. So if you are trying to reverse engineer software, and you want to do it because you want to make sure that elections are secure, that doesn't protect you against violations. And I just think it doesn't seem right to me. What can I say?
Run for Congress?
Yeah, thanks.
Isn't there, I can't remember offhand because this isn't my area, but on the civil side, is there also the damage requirement that you have to cause a certain amount of?
Yeah, I think there is.
Well, there's a separate provision of the CFAA which deals with one who knowingly causes the transmission of a program, information, code, or command as a result of such conduct intentionally causes damage without authorization. So that's a separate provision from the one that triggers a lot of the discussion about in excess of authorization or without authorization. Let me say this because it's a point I wanted to make. One of the things that I think happens with the CFAA is if a trade secret case collapses, and we had this situation, the client was arrested, charged with trade secrets violations, they could never prove any transmission of secrets to anybody else. But what he had done when he left the company was wiped his company computer clean. And the government charged him with a federal felony on the grounds that the wiping clean of the company computer without being told by the company that he could do that constituted a federal offense. What we were arguing, but it was totally internally. There was no internet connection or anything, so it doesn't meet the definite transmission. It was a judge trial. The judge said, no, but internal will do it for me. So then he was left with, but what's damage? And the government took the position that any deletion of anything from your company computer, it doesn't have to be wiping it out, any deletion without authorization is a federal offense. And we said to the judge, you can't buy that. And he said, well, I can't, but where do I draw the line? And what happened is it was a judge trial. It was submitted to him. 6 weeks later, he came out with an order that says the defendant is acquitted. No one asked for findings of fact or for explanation of law, so I'm not going to give you one. So that issue, among others, is still out there hanging. What deletion constitutes damage for the purpose of the CFAA?
All right, let's move on. We've got 3 more topics and see if we can hit them all. This one is captioned due process against predictive algorithms, daughter of Loomis. We had the son of Carpenter. I needed the daughter of Loomis. For those of you who may not be aware, there was a case out of Wisconsin where the trial court had used a predictive algorithm system produced by a company called Compass in order to determine what the sentence of a defendant should be. Now, to clarify and be fair, the court used a number of different factors, not just the Compass report, but the defendant wanted to see the algorithm that was being used and wanted the data that the algorithm used in order to make a recommendation. And the company wouldn't give it to him, and the state wouldn't give it to him, and the court would not order it. And that went up to the Wisconsin Supreme Court, and the Wisconsin Supreme Court upheld the decision of the trial court. And that went up on cert to the U.S. Supreme Court, and the Supreme Court refused to accept it. The Solicitor General's office submitted a brief that said, you know, this is an important issue. Someday you should get around to it, but not on these facts. And the court agreed with that and denied cert. All right, so what is the problem with having proprietary software making decisions for people? And there's an interesting case that came out of the Southern District of Texas trial court. The school district here was evaluating its teachers, and it was using the software of a private company in order to do that. And the private company was using a proprietary algorithm and accessing confidential student data. The teachers were denied access to the data and to the algorithms. And what's more disconcerting, and I'll explain this in a moment, the evaluation results could not be reproduced. And it's not because the algorithm didn't work, it was because if you change the data from day to day, the algorithm functions differently or produces different results. And if you change the data for a particular teacher, the results for a particular teacher, then the algorithm will change the results for all of the teachers because they're connected. So the district, the school district, filed a motion for summary judgment asking that the case be thrown out, and the court denied it, at least with regard to the procedural due process aspect. What the court found or held was that it's untenable for an employee of a state, in this case, these were county employees, to not know how they are being evaluated and why they may be terminated from their jobs. They have a right to challenge any such decisions. And if the data is confidential and the algorithm is proprietary and for that reason not being disclosed to them, then that is a violation of procedural due process. And going a bit further was the question of what happens if you can't reproduce the outcome, so that, well, that piece of data is incorrect. Let me give you the correct data and let's run it again. The problem was you couldn't run it for just one teacher. You needed to run it for the entire school district, and that was financially prohibitive, and so the school district would not do it. And I'll just explain to you why that is a problem. What's on the screen right now is what we call a neural network. And these are being used more and more often in technology today. You get on Google and you do a search for something, and you're going to encounter a neural network somewhere that's going to decide what information it's going to give you. And the way it works, you see this schematic with a lot of nodes and a lot of links. And what you need to understand is while the data flows, in this case from, say, left to right, data also flows backwards. So that as you are progressing with your algorithm, you get a result at node on, say, the third line or the third column of that diagram. It's going to send information backwards to the second column, and then it's going to recalculate and send it back forwards to the first column. And each time it does this, it's going to change the importance of those links. This is actually the way the human brain functions. And that is why you can form memories and why you can do calculations faster the second, third, fourth, fifth time that you do it. Because the brain forms links and weights those links. And that's what's happening here. So if you have a situation where you cannot reproduce a result, then how are you going to determine whether, in fact, your evaluation is accurate? And in this case, the court said, no, the teachers have a legitimate interest in determining that their evaluations are accurate, and if you can't provide the data and you can't reproduce the results, they have a case. Now, this is the first instance of me raising something pertaining to law outside of the United States. And it's the European Union's General Data Protection Regulation. And I point it out because it actually provides that when decisions are being made, not just by governments, but by companies, regarding a data subject, a person, then the person who is the provider who is making those decisions must be able to provide the information to the subject that is necessary to ensure fair and transparent processing. And if there's an automated system, then you have to provide meaningful information about the logic involved. That is in direct contrast to many of the legal principles we have as demonstrated by the Loomis case. But more concerning to me is I don't even see how this particular law is going to be capable of being implemented because of the type of computer technology that we're embarking on. Barbara, do you have anything you want to add to that?
Well, I mean, I just find it disconcerting that algorithms are making critical decisions such as deciding penalties in court cases for defendants. And these defendants, or in this case the teachers, have no recourse. I mean, these algorithms are written by people. They reflect people. I mean, we know that many of the algorithms reflect people's biases, and to just give the algorithm carte blanche, I just think is reprehensible.
Well, I would agree with that, Barbara. I'm not a trial judge now, but I certainly have been. And currently, I am doing a good bit of work with another professor on the whole issue of implicit bias. And people normally say, well, you know, the computer is neutral, and you put, I mean, it will print out these exact results. But, you know, if you have this system, and I'm not saying by any means that algorithms are garbage, but it's that same principle, garbage in, garbage out. Algorithms are created by people, and to the extent that people embody biases, preconceived notions, embody stereotypes, and things like that, those things are baked into, potentially, the algorithms and will negatively, potentially, or positively impact the outcome. So it's not just neutral. It is affected by those things, and so that's something that I think we ought to be concerned about.
Let me raise one more thing about the technology involved. As Judge Donald mentioned, we often say, well, the computer is neutral. And as she also said, garbage in, garbage out. There's a very interesting example of a research project done at the University of Washington in the state of Washington, where a computer algorithm was set up to examine pictures of dogs, huskies, and wolves, which are very similar in appearance. And the researchers were very pleased with themselves. They had written an algorithm that correctly identified 97% of the time whether a photograph was of a husky or it was of a wolf. And then they added some code to the algorithm which would tell them just how the algorithm or how the computer was making its decision. And they found out that the algorithm was not focusing on the animal itself. It was focusing on the background. Wolves, pictures of the wolves, were from outdoors, grass, trees, dirt. Pictures of the dogs were in their homes, furniture, carpet, people. And I should have added, this was a self-learning algorithm so that it was adjusting those weights and links I showed you earlier on its own. So the concept of garbage in, garbage out, and you need to know how the system is working. And if you are going to be sentenced to 10 years as opposed to 5 years based on an algorithm, you really do need to be able to analyze the algorithm as it pertains to you. All right.
And people are also starting to use those in some of the HR departments to aid in hiring. And so you have those same cautions, I think, anytime you're embracing this.
Andrew, can I just add one other quick point?
Yes.
You noted on the slide that the GDPR applies a transparency principle for the use, for the basis of the decision making. I'll also note that is a further application of the same openness and transparency principle, that just to make the point that this isn't purely sort of a European concept that dates all the way back, traces back through the 1990s Data Protection Directive, the 1980 OECD international guidelines, all the way back to the report that was done in the US by the House Department of Housing and Urban Welfare, the HEW report. So really, all this stuff does flow back from the fair information practices that were developed here in the US.
And Andrew, I'm just going to interject one more, and I know you have something
yeah.
to say, but I hope that we are going to have a few minutes for questions because we have an incredibly international audience in the room. We have someone here from the Northern Marianas, somebody here from Japan, somebody here from the UK. We have somebody here from the Bank of Ghana. We may have some other people from international countries in the room. We did have a military colonel who now had to leave, and we had the police chief from St. Petersburg in the audience. He stepped out, and because we have such a rich and internationally diverse audience, it might be interesting, some of the questions might be. So I hope we have a few minutes at some point in time for questions in the event some of those individuals who represent financial services, who represent companies and other things in the audience.
Yeah, and I just wanted to add sort of a generic comment related to this prior conversation, that I think people put far too much faith in computers, in the results of computers, and there should be a hell of a lot more skepticism and more willingness to ask questions. I've observed that sometimes people can feel intimidated by technology and feel if they don't understand something that they're stupid. And I think, in fact, it offers the case that they're just, someone's selling them a bill of goods, and they should be asking more precise and decisive questions.
All right. Well, the next topic is malware in the courts. You've heard, yes, this is her topic. You've heard of malware being introduced into corporate and government computers, and often ransomware, where the companies are being asked to pay up in order to get their data back or allow their computer systems to function as they should. Well, we have had an instance a couple of months ago in Philadelphia where the Judicial District of Pennsylvania, the first Judicial District of Pennsylvania, had malware inserted into its court workstations, and everything was shut down. And the court had to contract with an outside cyber specialist in order to get its operations up and running again. I understand that the federal courts have taken action to avoid or minimize the possibility of this kind of problem. And you want to tell us a little bit what's going on?
I do, and I want to do that quickly because since I said I wanted you to have an opportunity to ask questions, I didn't know I was next. When Andrew asked me to talk about this particular topic, no offense, but I said to myself, I'm going to go in and do sort of the George W. Bush presentation. I'm going to say, malware bad, strong security good, and then we can just go from there. But the courts deserve better than that. And I'm going to be talking about the federal courts because I know we have a state court judge from New York in the audience, and I can't speak to the state courts here or elsewhere. But In the federal system, IT security has been a priority for the Judicial Conference for a number of years. I mean, it is a priority for all of the 300-plus federal court units operating within the 94 districts and 13 circuits of the judiciary. We recognize that IT security threats and risks are progressively more sophisticated and dangerous than they were, and they're only going to get more sophisticated and increasingly dangerous. And you might think, why would courts be a target? And they really are, because all of this wonderful information that comes into the courts for resolution and to support the arguments you're making, it contains valuable information for those who wish to do harm. And so it's incumbent upon us, just as it is upon you, to provide protections for that data. So to combat these threats, the federal judiciary operates a national IT security office in DC. Within this office, there's a network operations center which monitors and evaluates all network activity. There's also a security operations center which monitors and mitigates threats and attacks 24/7, 365 days a year, and 366 in that rare occasion when we have that many days. In the month of June 2019, the Security Center identified and monitored 25 million IT transactions identified as potential attacks to federal judiciary systems around the nation. 25 million. Of the 25 million processed, 1 million attacks were identified as clearly harmful and were summarily blocked. In the same month, approximately 1,000 transactions or potential attacks were isolated for further investigation and review by the Security Center analyst. And that's just an average month in the life of the courts. In addition to the efforts by the Security Center, the judiciary has 12 regional IT security officers who administer a comprehensive system of monitorings and risk aversion activities within the various circuits. How do they do that? Well, like you, we depend on, in many instances, these commercial providers for the tools to help us maintain the security of the system. It is led by an AO unit, but we use things like the CASE automatic tool for identification and inventorying of all devices on our network. We use tools like Nessus, the vulnerability scanner by Tenable. We use CyberArk. We use WebSense. Then we use training things like Blackboard, Lynda.com, and other computer-based learnings. We also have implemented a hard password security provision, which changes frequently. I mean, I think about every 3 to 6 months. Everybody connected with the court has to go in and change passwords or you're locked out. And the team is constantly scanning for all kinds of activity. So we use a nested system of network firewalls at each location and at our internet data centers. And we escalate identified threats and or breaches to an organized incident response process. We try to hire and we constantly increase personnel. A lot of times we're hiring them out of private industry, but bringing in to augment the teams to make sure that we have a safe environment. And a key tool that we use is to really educate all of the people connected with the system about what to do to try and help us keep the center safe. Having said that, that's what we're doing at the federal level. I know that we handle a small fraction of the nation's court business. The state courts handle a lot more. And as we advance by our e-filings and all of the electronic stuff, we get all of the corresponding problems. And I think the state systems are also getting into the e-file and all the digital information storage and provision. But I have no idea what's going on there. That's just a rough thumbnail sketch, because I know you came here this afternoon because you're interested in this topic. and all of us are aware of many of the issues and many of the threats. So we want you to have enough opportunity to at least have a question. So when I turn it back to our fearless moderator and organizer. And,
Well, I am going to address, or have us address briefly,
okay,
Europe, the General Data Privacy Regulation and the Data Privacy Act, and what has become known as the right to be forgotten. And I've captioned it, the EU against the global internet. Alan, can you tell us a little bit what's going on?
Sure. I'll be brief here so we can get to some questions as well. Many folks may already be familiar, but a quick background on the right to be forgotten. Under the European General Data Protection Regulation, there's an affirmative right, sometimes it's described as right to be forgotten, right to erasure, but the right to basically cease a particular type of processing of personal data. Then the right to be forgotten phrasing comes out of a decision by the highest court in the EU, the Court of Justice, in a case called Google v. Spain. Just one key thing I'll highlight about that decision, the underlying dispute was over an article that was several decades old about individual bankruptcy proceedings, and an individual was seeking to have that material delisted from Google. The underlying article was published by a Spanish newspaper, but the Court of Justice did not prohibit the Spanish newspaper from hosting that printed material or the written material. It prohibited Google from, it required Google to delist it from its search engine based on pairing it with the individual's name.
and it's important to note that there was no allegation of falsity contained within that article.
True. There was no allegation of falsity. The standard is not false information under the right to be forgotten, but the applicable standard has to do with whether that information is still relevant or disproportionately harmful. But I do think when comparing it to the U.S. system, and there's sometimes concerns raised about the First Amendment implications of delisting, I think it's notable that the Court of Justice was taking action with respect to Google's search indexing, not the newspaper's publication of the information. So the questions that were left after the Court of Justice ruling in the Google v. Spain case included a question about how that rule would be applied in a global internet. And that has come to bear in a case that's now pending before the Court of Justice, which arose out of a French enforcement action. The French Data Protection Agency is called CNIL, and they brought an action against Google requiring delisting of certain personal data, and specifically requiring delisting in all of Google's domains, so google.com, as well as google.fr and other EU domains. What's happened so far is that case has been briefed in the Court of Justice. The Advocate General, who is it's a different system than the U.S., but essentially imagine the Attorney General of the United States gave advisory opinions about what the Supreme Court should rule, and sometimes the Court follows them and sometimes they don't. So that's what's happened so far. Is there's been an opinion by the Advocate General in June of this year that advised the Court that they should not require companies to delist from all domains globally, but instead should only require them to delist from access to those results in the EU, which means both access to the EU domains, .france, .spain, et cetera, and also essentially geofencing, so access from within the EU using IP addresses. So that's the advice of the Advocate General, and we're waiting on a decision by the Court of Justice on that.
If that's adopted, what happens to a .com or .org or .net domain?
If you take the Google example, Google would not be required to delist the search results from google.com, but if an individual searched Google, regardless of the domain, from within the EU based on IP address screening, they would have to delist them.
So if I'm sitting in Paris and there's information that has quote unquote been delisted,
Yeah.
and I log on to google.com, am I going to be able to access that information?
It will be it should be delisted based on this recommendation. Again, the court hasn't adopted it yet.
What happens if I try to access it by first going through a workstation in the United States and then back out?
If it's IP address geofencing, then they would see you as coming from the US, and so you'd be able to access it. One additional point I'll note about the US-EU comparison is we do delisting in the US. We just don't do it already. We just don't do it for privacy. We do it for privacy statutes. We do it for child pornography. We do it for websites that allegedly violate intellectual property rights. So the broad arguments that are made under the First Amendment that must be a First Amendment violation to delist things, they just don't hold water because we do delist things in the United States.
All right, we have 5 minutes for questions. Anybody?
What was a number of years ago, there was whatever investigation within the FBI were trying to seek access to an Apple phone. Eventually it was transferred to the Israeli Secret Service and they were to try and gain access to it. But could you just discuss what the issues are with that? Because it's coming up, certainly was a case in Northern Ireland about the police trying to look at materials that were from journalists and that investigation was stopped. But it's popping up in some European countries, self-incrimination issues, but also journalistic privilege and other type of issues. So just to explore what the issues might be, and is there any case on the way about this?
There's a couple different related issues. The FBI v. Apple case was kind of a unique case in the US system because it had to do with the ability of a court to order a company to make changes in application software or hardware that would make it easier for law enforcement to access a device, right? So Apple, in that case, they're not alleged to be participating in a crime. They don't have any data. All they have is theoretically the capability to change the software in a particular device in a way that would make it easier for law enforcement to crack it. That case ultimately went away because law enforcement sent the device to Celebrite, the Israeli company that was able to crack it anyway, and so it was never resolved. My organization, Epic, filed an amicus brief on Apple's side in that case, arguing that the courts should not be allowed to order a company to make software that makes all devices insecure as a cost to potentially easing access to a single device. And that's the general position that we and many others take with respect to engineered insecurity, basically creating backdoors. There's a really good report called Keys Under Doormats that I'm sure Barbara's familiar with, that has really excellently written, better than I could ever explain it, but it's a major issue.
And I mean, law enforcement has for years been trying to get access to encryption, going way back to key escrow under the Clinton administration. And the pushback from the technological community is this is a two-edged sword. We understand that law enforcement would like to be able to read certain things, but if you weaken encryption for law enforcement, you weaken encryption for everybody. And it basically makes our whole system more insecure.
You know, one of the things, and Barbara knows this better than do I, encryption is basically based on a mathematical algorithm. And in order to put a back door into that algorithm, you have to tweak it in a certain way that then can become the target for an attack. And you cannot put a back door into a mathematical algorithm and expect that the algorithm is going to be as strong as it was before. It's like the weakest link in a chain.
And it would basically make our whole financial system highly vulnerable too, because transfer of funds highly depends on having strong encryption algorithms.
And another related point that you raised has to do with compelled decryption. So many devices either are password protected or may be protected by a PIN or a facial recognition function or a fingerprint. And those issues are very much alive in U.S. courts about when and under what circumstances an individual can be compelled to do any of those things. I think that issue will inevitably go up in the U.S. Supreme Court soon because there's a lot of different directions it's going. There's a case, Epic just filed an amicus brief in the New Jersey Supreme Court about that issue. And there's a lot of complicated questions under the Fifth Amendment, but I think in general, compelled use of biometrics to unlock devices is problematic, in particular when it reveals, something more then the law enforcement already knows about the relationship of the individual and the device. So there's one example where a law enforcement officer requested a court give permission in advance to go to a house, and at the time they arrive at the house, to force anyone in the house to put their thumb on any device that's in the house, and which would actually link particular individuals to particular devices that law enforcement didn't know in advance. For example, if the cell phones were sitting out on a table, you don't know which one is whose. And that's actually like an act of identification that I think goes to the heart of self-incrimination.
Any other questions? Well, we've hit 3 o'clock, which is when we're supposed to stop, so the timing is pretty good. And I thank you very much for coming.